Today we're going to talk attorney fees and probate. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. First of all, this video is for educational purposes only. I am not giving legal advice. And secondly, this video is going to be about primarily Minnesota law. So if you live in another jurisdiction and you have questions, make sure to talk to an attorney in that jurisdiction. So there are basically 4 ways of billing in probate. And remember, probate is litigation. Previously, we talked about estate planning. That's a transactional practice. Estate planning or probate is going to be a form of litigation, even though a lot of it's very procedural. The 4 ways of billing in probate are going to be hourly, flat fee or fixed fee, contingency, and AltContingency. And we'll walk through each one of these here. The first one is hourly. Very simple. You're going to, if the attorney works X number of hours, they'll multiply that by their hourly billing rate, billing at 1/10 of an hour, and you, by the end of it, when you add it all up, that's what you will be billed. It's the most popular and the most common ways of billing in probate because you just don't know what's going to happen. You will, on top of this, be billed expenses, of course, and generally there will be a retainer required to enter into an hourly arrangement. The second way of billing, which is much more rare, but I think there are certain people in the industry that are moving in this direction. And interestingly, in probate, because it is a lot more procedural than general litigation, you can get away with it. And this is using a flat fee. Generally, what you will do is break down the probate into a certain number of steps, step 1, 2, 3, 4, and 5, for instance, and you will say step 1 will cost you $1,000, step 2 will cost you $500, step 3 will cost you $1,000, etc., etc., etc. You may or may not bake into these amounts the filing fees or the publication fees or other expenses. The nice thing about this is if you can swing it, it's very predictable for what the client's going to have to pay. The challenge with this is if anything out of the ordinary happens, if there is a contested will, for instance, or if there's complicated tax work, or if there is a complicated sale, it's not going to be reflected in the flat fee. And in fact, if there, for instance, is a will contest, the attorney will probably have a provision in the retainer agreement that says if there's a will contest, we're moving to an hourly basis immediately. The third way of billing in probate is called contingency, and this is where the attorney will earn a percentage of the gross value of the estate or the winnings, depending on whether the case is successful. You will see this most often in contested wills, or in will contests. For instance, if someone is contesting a will and thinks that they're going to earn $500,000, the attorney will say, I will represent you, but if we win, I get 30 to 50% of those winnings. So if they set it at 50% and the winnings are $500,000, the attorney walks away with $250,000. That's steep and that's expensive. However, remember, if you lose, you owe nothing. If you're on an hourly basis and you lost, then you're going to owe the attorney something and you won't have won anything. So sometimes it's the only way that people can swing it. These are generally only appropriate for will contests, though I have heard of people doing them in probate. But I would say in probate, try to stick to the hourly, or if you can, get a flat fee. The fourth way of billing in probate is called the AltContingency. We're going to go back in time to 1964, to the 1964 Hennepin County fee schedule. And this is something that Minnesota used to have, or Minneapolis is in Hennepin County, so Hennepin County had this. And under the fee schedule, for the first, and this is for doing a normal probate, for the first $50,000 of the estate, the attorney got 4% of the estate. For the next $450,000 up to $500,000, the attorney got 3% of the estate. And for everything above $500,000, the attorney got 2% of the estate. So let's say we had a $10 million estate. the attorney is going to bill $2,000 for the first 4%, $13,500 for the next $450,000, and $190,000 for the next $9.5 million. This means the attorney is going to walk away with over $200,000 of that estate. This is regardless of whether there are any creditors. There could be one beneficiary, one house worth $10 million and no other assets. The attorney's still going to walk away with over $200,000. Now, Minnesota has now abandoned this type of fee schedule, though some other states do maintain this fee schedule. That's why in other states you will see people push for revocable living trusts so much, because in a trust you can avoid having a mandatory fee schedule. You can move it to an hourly or a flat fee or however you want to bill it. In Minnesota, under Minnesota 524.3-715 that gives the authority to pay compensation to attorneys in a probate. Now, the standard for this is under Minnesota statute 524.515 which is just and reasonable. There's a caveat, however, under the statute, which is under 525.515 that says that the value of the estate shall not be the controlling factor. As you notice in the fee schedule, the value of the estate is the only factor. So we've gotten rid of that in Minnesota. The correct factors for determining how much to bill for probate is under 525.515 and it provides 5 different factors. It says the correct factors are looking at the time and labor required, the experience and knowledge of the attorney, the complexity and novelty of the problems involved, the extent of the responsibilities assumed and results obtained, and the sufficiency of the assets properly available to pay for the services. So that's what we're looking at when we're billing for probate. And that generally means that we're going to fall under an hourly billing scheme or possibly a fixed fee. So that is my take on billing in probate, attorney fees in probate. If you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. If you like today's video, we do a new video every other Wednesday. We've got some great topics coming up, so stay tuned. If you have any questions or comments, leave them in the comments below or just send me an email. I'm happy to get back to you. Otherwise, until next time, this is Gregory Singleton with Signature Law.